Every single day of the party primaries brings with it excited winners and shocked, dejected losers. An unfortunate reality that has not spared even those considered to be political giants, including William Kabogo, Jakoyo Midiwo, Samuel Chepkonga and Moses Ole Sakuda, to name but a few. Others have been rejected by party members after only one term in office, including Governors Dr. Cleophas Lagat, Benjamin Cheboy, Joseph Ndathi and John Mrutu. Serious contestation of results has arisen, but ultimately those who felt they had been unfairly rigged out knew they still had a lifeline in other parties, or at worst ran as independent candidates. The court has, however, limited their options to only one, following a petition filed by the Council of Governors challenging a clause in the Elections Amendment Act barring party hopping.
If any individual is not successfully nominated, his inability to shift his allegiance to another party within the time frame spelled out in IBC cannot be said to be a limitation of his right.
Now it's access denied for nomination losers who are already racing to enter rival parties after losing in the primaries, even as they grappled with rejection, whether by voters or their parties, as some have raised complaints of rigging.
I was at the tallying center, where I was told these guys were cooking, and truly the broth is good. It has been cooked.
It's a double streak against nomination losers, whose political future has now been limited to their own devices as independent candidates. Political analysts reckon that political parties are instruments of political power, the vessels upon which politicians sail on, their fame and influence propelling candidates a notch higher. In some instances, a euphoric wave has helped some candidates secure political offices. It's the reason why, in its wisdom, the Council of Governors challenged a provision in the Elections Amendment Act barring party hopping to give losers a political lifeline, at least within 120 days to the election.
To me, this petition is premised on a clear misapprehension of the law. In view of my findings here in above, I find that the petitioners have failed to demonstrate that the challenged section is unconstitutional or in any manner infringes any provisions of the Constitution.
By restricting party hopping, pundits observe that the court is trying to establish solid political institutions with ideological identities and not just political vehicles to be used at the whim of politicians.
In my view, the challenged provision is necessary in a democratic society to ensure proper preparation and management of the electoral process. What seems to me to be important is that the pre-election process within a political party is such that it is transparent and transparently exercised, free of any taint of electoral fraud or coercion, and one in which party voters are at plebiscites and voters at general elections can know with confidence that fair means produced a candidate.
The Council of Governors petition, according to Justice Chacha Mwita, has no merit at all. Sylvia Chebet, Citizen TV, Nairobi.